Hi, everyone. Today, we're going to look at some of the European Union's top regulatory developments around data privacy, cybersecurity, and more for 2024. I'm your host, Bill Coffin, and this is the Ethicast. 2023 was a very busy year in the realm of cyber risk and compliance, with new laws passed around the world on the state, national, and international levels to further protect data privacy and bolster cybersecurity, including new reporting and disclosure requirements. Numerous efforts began to establish standards around the responsible development and implementation of artificial intelligence. And all throughout, enforcement agencies reminded everyone that they can and will levy large fines against those organizations that fail to live up to standards or act in good faith. The European Union has been at the forefront of these developments, upholding its long history of taking data privacy and cybersecurity very seriously on behalf of its citizens and establishing high watermarks for global ethics and compliance programs to meet or exceed. As we look to the year to come, the EU's regulatory pace is not expected to slow down, which leaves ethics and compliance officers with a pressing question: what's in store for 2024? With us today to share his insights is Alex van der Wolk, partner and co-chair of Morrison Foerster's global privacy and data security practice. Based in Brussels, Alex advises global companies on data protection strategy and compliance, governing all aspects of information management. Alex, thanks for joining us.
Thanks, Bill. Pleasure to be here.
By October 2024, EU member states will need to have applied into their own national laws the NIS2 directive, the EU-wide cybersecurity legislation that provides legal measures to boost the EU's overall level of cybersecurity. That is only 10 months away. So can you tell us what major challenges we can expect countries to struggle with on this? And most importantly, what companies can do on their end to ensure that their own cybersecurity efforts align with what the EU expects of them?
Absolutely. And let me start by referring to the fact that this is the NIS2 directive, which means that there is an NIS1, which dates back to 2016. It was or is a directive similar to the NIS2 framework, which means that it's European law, but it needs to be transposed into national law. And until that time, there is no direct effect, if you will. Now, this one is and has been implemented into national law, so we have some contours, but there are quite a few fundamental differences with NIS2, one of which is the scope of applicability. So you saw that NIS1 was very much focused towards critical infrastructure. NIS2 is designating a whole lot of other areas and sectors as covered in scope of the framework. To give an example, it's banking, it's financial services, it's to a certain extent. It's postal courier services, quite a few areas and sectors that weren't in scope of NIS1. What you will see for the next 10 months or so to come is that member states will have to transpose NIS2 into their national laws. And if there's anything that we've learned from NIS1 is that not all member states are going to meet that that deadline. There are inevitably going to be member states that will miss the deadline. There will presumably also be member states that will be ahead of the deadline, but a lot can happen between now and then, and we'll have to see what the implementing laws will look like. Another thing to look out for is that the implementing laws will give further nuance and contours towards companies that will be subject to this new framework. We know the sectors; those are defined by the European legislation, by the directive itself, but we don't know the thresholds. Those will be set by the national implementing laws. And so, what we saw with NIS1 again is that those thresholds may differ. And same sector, same company may be subject in one member state but not in another because of the difference in thresholds. So a lot will happen between now and October and presumably beyond. For us to know, what this will look like, and for companies to figure out whether or not they're going to be subject to this.
You mentioned that not all countries are expected to make the deadline, and this is not unexpected, but do you have a sense of, are there any particular countries that really kind of stand out as widely expected to not make that deadline?
Yeah, that's a great question. I'm not sure if they're notorious offenders, if you will, in the sense that there are countries that almost by default miss the deadline. It really differs. I think it differs towards whether or not the national authorities are already set up. It also depends on how much priority this gets on any member state's political agenda. To give you an example, Germany, as one of the few, to my knowledge, has already drafted an implementing law, which got leaked in 2023. So we know where Germany is heading towards, and I'm pretty confident that they will have something by the deadline, if not before. But difficult to say whether all of the countries will make it, and if not, which countries will be those that won't. In terms of what companies can do to prepare, I mean, the thing with these cyber frameworks on a European level is that they provide high level requirements in terms of the actual cybersecurity requirements. And so if you're anticipating to look towards these frameworks for the detailed cybersecurity requirements, you're going to end up disappointed because they won't contain them. They'll be high level. They'll say things like you need to have an appropriate governance framework. You need to have a procedure to be able to respond to data security incidents or incidents covered by these respective frameworks. So the issue here, I think, is mostly to make sure that you have a procedure, a policy, something in place that allows you to respond to vulnerabilities, to cybersecurity events and incidents. I was on a panel with one of the European members of parliament back in October, and he indicated that the penalty regime, just to give an example, the penalty regime under NIS2 isn't so much there to penalize companies for getting breached or being attacked. It's there to incentivize companies to have a framework and a procedure in the first place, to make sure that you have something, and to make sure that you revisit your policy time to time, make sure that it's still appropriate to the types of security risks and cyber risks that you face. So I think it's that area notably where companies may want to have a look towards their preparation for NIS2, in addition to, of course, assessing whether or not they're going to be subject to NIS2. And then in addition, I think it's really a lot about making sure that you have the ability to make the appropriate notifications once they're required. A lot of companies in the EU, I think, over the last couple of years have gotten used to the GDPR type breach notifications. Here, the thresholds under NIS2 are going to be different. The timelines are going to be different, and the authorities are going to be different. So to the extent that companies have incident response plans in place, which would be a very good recommendation to have, it'll be good to revisit those and make sure that they accommodate the notification requirements that will come into play under NIS2 and the Cyber Resilience Act, which we're no doubt going to be talking about in a moment.
Speaking of the Cyber Resilience Act, as that gains further traction in 2024 as part of a global crackdown on cybercrime, what do you think will be some of the most significant developments to this emerging security framework? And again, what is some of the heavy lifting that you imagine this might impose upon companies whose products and services will be placed on the EU market?
Yeah, and I think it's important to acknowledge that. So we're talking today about NIS2 and the CRA, the Cyber Resilience Act. They're part of a more encompassing cybersecurity framework. There's also DORA, the Digital Operational Resilience Act, which governs financial sector first and foremost. But the whole intention with this framework is twofold. One is to make sure that the cybersecurity posture of European companies is up to par. And second is that these frameworks go hand in hand. They are intended and drafted not to overlap too much. The reality is going to be that some companies are definitely going to face that kind of overlap. Just to give you an example, NIS2 regulates the banking sector and financial services, as does DORA. And there are going to be overlaps between the Cyber Resilience Act and NIS2 as well. But they're intended to exist side by side. CRA, the Cyber Resilience Act, deals with digital products that are placed on the EU market. So if you're a manufacturer or a distributor or an importer of products that have digital components, and that are connected one way or another to a network, then you're going to want to pay attention to the CRA and assess whether or not you're going to be subject to those provisions. The thing with the CRA is that, like NIS2, it introduces a lot of what I would say common sense cybersecurity requirements. Again, having a governance policy in place, being able to respond to incidents, making notifications. The thing with CRA, though, is that certain products are going to be required to get a CE marking. They're going to have to go through a conformity assessment. And depending on the criticality of those products, it's either a self-assessment or it has to be done by an external third-party certified auditor. So it's one of those things. Again, if you're in the business of placing connected products on the EU market, then you're going to want to keep an eye out for these kinds of things. The one nuance I will make is this regards products that are placed on the market. So we're talking about resale. If you're a manufacturer of products that you develop for your own use, but you don't make them available to third parties, to customers, directly or indirectly, then you're likely not going to be subject to CRA with regards to those kinds of products.
Ethics doesn't just happen. You need to put in the time. So make sure to register for the 15th Annual Global Ethics Summit, a live and virtual event in Atlanta, Georgia from April 22nd through the 24th. Save $200 by using the code ETHICAST at registration. To learn more, visit attendges.com. Can you talk about some of the landmark privacy cases that the European Court of Justice issued in 2023 and what some of the most closely anticipated decisions of 2024 might be?
Yeah, well, we had a lot of cases issued by the Court of European Justice in the EU. We saw a number of cases being issued around the question of damages in a privacy context, be it in a private litigation one-to-one or in a class action litigation situation. But there's the provision in GDPR that says if you're a data subject and your data was the result of a violation of GDPR, you may be entitled to damages. Now, especially in the class action context, that has spurred a lot of cases, a lot of claims being brought in European context, and many of those questions revolve around the question in which situations individuals are entitled to compensation, to damages compensation. And there have been a few landmark cases throughout 2023 that have said a couple of things. First is the mere violation of GDPR in and of itself doesn't award damage compensation. There has to be some form of actual damage sustained by the individual, and the individual has to evidence those damages. So you can't just put up your finger and say, oh, I saw that such and such company did not have a privacy notice published on its website. Can I collect? You'll have to show that you were damaged, actually damaged, which could be immaterial damages, but still actually damaged by that violation in order to claim compensation. So I think that's a big decision. We're going to see decisions around that same question into 2024, more on a factual or nuanced level, such as what if it's a data breach and I was, my data was obtained by a bad actor? In what circumstances would I be entitled to damages in those cases? So that's one thing to keep an eye out for. Another, I think, very interesting decision in 2023 was the Schufa case, which set boundaries around when processing of personal information qualifies as automated decision-making. You may recall that GDPR provides that if processing is automated decision-making, there's a whole lot of restrictions that come in place. And basically, you can only do that on the basis of explicit consent. And there was a question: what circumstances what kind of processing amounts to automated decision making? In the Schufa case, it was held that even if you're a party that provides reports, profiling reports, but you don't take the actual decisions on individuals, but you provide those reports to another party, to a third party who takes those decisions, you in the first place as company is providing those reports can be engaging in automated decision making such that you're subject to that, to those restrictions under GDPR. And we're going to see more of those cases into 2024, no doubt, that will set the contours around GDPR and its provisions.
What are some of the most interesting AI developments likely to emerge this year that ethics and compliance professionals should monitor?
The
Yeah.
EU's AI Act was in preparation and development throughout 2023. It went through the legislative process. We're pretty much almost there. We know that a political agreement has been reached about the contours of the AI Act, but we haven't seen its final publication yet. It is anticipated anytime soon. Could be this week, could be next week, but we do anticipate to see it soon. There will be a transition period before it takes effect. However, I think the most important thing to note here is that not just the EU but globally, people are minding what the EU is doing on the AI Act front. A lot of countries have already indicated that they are intending to model their own AI laws to the AI Act, and it's the first of its kind, I think, where it sets a comprehensive framework around the use of AI and the requirements of users as well as producers of AI. There will also be an extraterritorial effect that will stem from the AI Act. So, even if you're not established in the EU, you may very well want to take note of the EU's AI Act when it's here, especially if you're a producer in one way or another of artificial intelligence.
Alex, thanks so much for joining us. I learn something from you every time we get together and speak. So, really appreciate you being on the show. And it's always a pleasure to hear from our friends at Morrison Foerster.
Absolutely. Thanks so much, Bill.
To learn more about what 2024 holds in the area of cybersecurity, data privacy, AI, and more, please visit the Morrison Foerster Privacy and Data Security page at mofo.com. That's MOFO.com. And for a library of additional thought leadership on information governance, privacy, and cybersecurity, please visit the Ethisphere Resource Center at ethisphere.com/resources. I'm Bill Coffin, and this has been the Ethicast. For more episodes, please visit the Ethisphere YouTube channel at youtube.com/ethisphere. And if this is your first time enjoying the show, please make sure to like and subscribe either on YouTube or on our podcasting platforms at Apple, Spotify, Google, and Amazon Music. Thanks so much for joining us. And until next time, remember, strong ethics is good business.